Where's the what?
I just need to plug this in.
Oh, it's.
Do we not have another one?
Hang
There's one over here. I don't want to. Oh, you're not going to unplug the fan.
Yeah, unplug the fan.
Yeah, because maybe I can go over there. And if I
Because I can move the fan this direction and blow it this
well,
way.
this is it's not really necessary.
Well, it's not being used, but I'm already running this around. So.
Over here. Oh, you're not going to unplug the fan.
Yeah.
I can get that thing to work. Let me see.
What's the matter?
No, if I can get my remote to work, then I'm not gonna. Got this really nice remote. It's not. Yeah. Earlier in class, it wasn't working, and then I realized I hadn't plugged the USB thing in, which tends to work better when you actually. Okay, because this is a pretty nice remote. Yeah. It actually could work. Maybe I can stand over here.
If you want to switch the camera.
Oh yeah, no, I mean I could. You know, if it's easier, I mean I can stand over there.
It's up to you.
This is working, so.
I'm just not that good with remembering to move the camera.
All right, let's see. Is this? How far am I from? Ooh, this is like, weaning me from my laptop.
Where do you think you'll stand?
I'll
Oh,
stay here.
okay.
This is kind of nice because, yeah, I usually work off of bullet points and whatever. I'm going to use this, but it works really well. I'm not going to use it, but it's neat. Look at it.
There are any cats in here?
Yeah.
That's what you do. The best part of it, you shine it on the cat, and then you get the cat chasing it, and then you shine it on the other cat. That sounds really cool. I've actually done that. Put the subtitle on. Really? Go back.
You can start whenever. I have 701.
Okay. No.
We've got 15 folks streaming at the moment.
Okay. Well, thanks for coming, and those of you who are streaming, thanks for streaming. The title of this talk is Plessy's Revenge, and actually I'm referring to the case. Homer Plessy is not out for revenge, but the case of Plessy versus Ferguson might very well be, and that's my point. I will tell you in advance, there are a few places here where I have full text to read, and that's because I want to be completely clear with the language when I make some statements about the Chief Justice of the U.S. Supreme Court. I don't think that what he has done here is entirely his fault, but hopefully by the end of the night, people will look at Chief Justice Roberts and say, you know, the guy may be really good, but I'm not so sure about what he's doing here. And that's my theme here, is that the case of Plessy versus Ferguson should have been left in the dustbin of history, and Brown versus Board apparently left it in the dustbin of history. And my case tonight, well, you'll hear my case tonight. So on that note, I'm here to talk about the 14th Amendment, equal protection, Brown versus Ford, and the legal context of Brown and what's happened since Brown, where Brown came from, what it means today in our legal system, and I'm going to focus on constitutional interpretation without doing the really deep dive into the language, because the number of cases and the level of detail I'd have to do, not going to work in a presentation like this, take too long and put everybody to sleep, and I'm pretty good at that, but I'd rather not do that tonight. So I'm going to look at Brown versus Ford, but first, we've all heard of Plessy versus Ferguson, right? I mean, what's famous about the Plessy case? I mean, when you think about it, everybody's heard of Plessy versus Ferguson, separate but equal. What Brown did was ostensibly to reverse Plessy, at least in the realm of public education. And Brown is famous for good reason. It put Jim Crow on the other side of the Constitution. The Equal Protection Clause for years under Plessy was on the side of separate but equal. And Brown flipped that. And so we're going to look at the clause and we're going to look at the roots of Brown. But just for a second to get started there, let's look at a little bit of the language here. Because Brown versus Ford is one of the most inspirational cases, one of the one of the leading cases. Whoa, that's just fantastic, isn't it?
Went through the whole thing.
That was a quick presentation, wasn't it? Okay, well, thanks for coming. Anyway, let me.
Please pause for technical difficulties.
That was really something. I've never seen it go that fast.
I'm telling you, this room is temperamental.
Okay, so let's take a quick look at Brown versus Ford. And people are obviously familiar with some of what Brown versus Ford said. Everybody's heard of the most famous language of Brown. At least in the field of public education, separate but equal has no place. Separate educational facilities are inherently unequal. Everybody's heard that. And people are also familiar with Brown too. Court called everybody back in a year later and said, okay, how are you going to fix this? And the language we got, man, that was fast. Okay. Admit the parties to these cases of the public schools on a racially non-discriminatory basis with all deliberate speed. Now, I'm not going to make fun of deliberate speed like I usually do, because I've learned recently really where that term came from, and I have a lot more respect for it than I used to. I used to joke about deliberate speed, you know, it sounds like jumbo shrimp. There's just something about deliberate speed that sounds off. But one of the justices in particular used that language very, very carefully, very thoughtfully to say, do the research, get the background, make the clear decisions, and then do it as efficiently and quickly as possible. So it wasn't just a throwaway, but this is some stirring language. Some of the language sounds arcane sometimes when you read the Supreme Court, but again, you know, beyond just the famous language here and here, there's some interesting stuff in Brown versus Board of Education. Powerful stuff, things that you look at and say, well, yeah, that's when I think of equal protection laws, that's what I think about. Couldn't all fit on one slide, so let's pull a couple of others up here. Curtailing onerous disabilities and burdens and curtailing their rights in the pursuit of life, liberty, and property, such an extent that their freedom was of little value, and that's what the 14th Amendment was designed to do. Okay, the 14th Amendment is not, you know, insignificant. This was designed to basically enforce the absolute equality of the races. We got this wonderful stirring language. And I got one more here at the bottom. In view of the Constitution and the eye of the law, there is this, in this country, no superior dominant ruling class of citizens. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. And again, truly stirring stuff. Only one problem. Those last three, actually the last four, are all from Plessy versus Ferguson. And that raises a couple of questions. I mean, what was going on in this case to be able to say things like that and then say, oh, by the way, separate but equal? First of all, this last quote here is from the dissent in Plessy. And John Marshall Harlan's dissent is one of the great famous dissents. He was known as the great dissenter, but this is maybe his most famous dissent, where he refers to the colorblind Constitution. And it's brilliant, it's eloquent, and I think it's wrong. Not wrong in his sentiment, not wrong in what he was trying to do, but when Justice Harlan talked about the colorblind Constitution, he was talking about what the Constitution ought to be. And I think in that sense he was wrong, because Plessy and the Plessy case is really talking about a colorblind Constitution. The Constitution doesn't pay any attention to race, and therefore we're free to discriminate. We're free to have laws that discriminate because, hey, the equal protection can mean separate but equal. And the concept of state action, which I will talk about in a few minutes, that is built into the 14th Amendment and has always been there, can mean something as simple as, well, yeah, but the law is powerless to address social discrimination or private discrimination. The law can only touch discrimination that's already been done by the law. The law can undo itself, but it can't do anything else. It can't try to solve societal problems. And Plessy stands for those things. So when you look at a case like Plessy versus Ferguson, the problem with Plessy was its insistence on a colorblind Constitution, one that doesn't see race as a problem, doesn't see it as a source of discrimination, of inequality, or harm or abuse. And a colorblind Constitution, again, as I said, can't address discrimination in the law. You can't fix it. Brown versus Ford came along and rejected the concept of a colorblind Constitution in favor of a government that was empowered for racial justice. And again, I'm talking about race more tonight because the level of scrutiny, and that's the focus. A lot of what I would say about Brown versus Ford and race, it is equally as applicable to other categories. Okay, my focus tonight, though, is on race as, if you will, the suspect classification. And so that'll make a little more sense as I go through this, but I'm not going to talk about the treatment of LGBT and sexual orientation by the court. I'm not talking about age discrimination or disability discrimination. All of that does apply to a lesser degree to the analysis here, but the focus here is on race, and I want to just be clear that's the way I'm directing it. So Brown versus Ford, again, rejected the colorblind Constitution. All deliberate speed is not a command to avoid any consideration of race. How do you do all deliberate speed to desegregate schools without considering race? It's impossible. And so Brown looked at that language, or the language in the 14th Amendment, and said, equal protection means something affirmative that you do. It's a realignment of the Constitution with equality, with justice, if you will, by and for the legal system. Now, on that note, I got one more quote to throw at you for my little introduction here. It's going to do it again. Watch, nothing, 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 and then 4 slides. You know what? This is starting to really bug me. Am I too far away? I wonder if that's the problem. Okay, well, this is getting a little ridiculous, so let's just see if the other one will work. You're going to be that way. All right. This is just weird. Okay, so the way to just stop discrimination based on race is to stop discriminating based on race. Just quick show of hands in the room. Who's heard that one before? Remember who said that? Well, yeah, it's there. Chief Justice Roberts. You know anything about the case? Because that's really interesting too. What Chief Justice Roberts was talking about was a case where Seattle was trying to prevent the segregation of its schools. And communities in Seattle were becoming more segregated, and they were more divided, increasingly divided by economic status, ethnicity, and race. And so Seattle said, okay, well, we don't want to end up with segregated schools. We don't have them now, but we don't want to end up with them. So what should we do? So they created a system of school choice, but if a school had more requests than available, they had tiebreakers. And tiebreaker number 2 was race. Not even the first one. That's actually, people select which school they want to go to, and they can pick the ones with special programs and everything else. Usually people pick closest to their home. But tiebreaker number 1 actually was you already have a sibling at that school. And then tiebreaker number 2, they looked at race so that no school would fall below a certain level. And when that case, well, let me back up. I won't talk about what happened in the case yet, but the goal there was preventing segregation. Meanwhile, there was a companion case decided simultaneously about Louisville, and in that case, the person who the family had brought the lawsuit didn't like the fact that their child who was going to be in kindergarten was going to go a couple of miles away instead of across the street. And in those cases, actually, when I discuss those cases in class, I usually get some comment about, well, it shouldn't be based on race, it should be based on merit. And my response is usually, kindergarten? What kind of standardized tests do they give for kindergarten? So, in any way, I digress. So, the point is, what's the Chief Justice doing here? He's asserting that Brown versus Board stands for race neutrality, for the government not considering race at all, and to him, that's what equal protection is. The way you stop discrimination based on race is to stop discriminating based on race, but he's talking about the law should ignore race. Treat it neutral, don't have laws that target race at all under any circumstances, and most important, for any reasons. So it's a plausible reading of the Equal Protection Clause. It really is. I mean, I think it's wrong, but if reasonable people can disagree about the purpose of and interpretation of the 14th Amendment, what I'm pretty sure about, though, is that's not Brown versus Board of Education. If you're going to make an argument like this, you have to deal with the fact that Brown says something very different. And unfortunately, the approach that's been taken by the Chief Justice, and again, not his fault, other things have happened in the kind of development, is that they read Brown and they see something very different. And he argues that this is what Brown stands for, that this is the legacy of Brown. So anyway, to the Chief Justice, equal protection is not about suspect classes, it's about neutral laws. And state action, the limitations on the state ability here, is to say if society is discriminatory, so be it. Law can't fix it because law can't consider race, and that's the colorblind Constitution. That's not Brown versus Board, that's Plessy. So how do we get to this place? And what I want to do to develop kind of how we got to this place is to do it again, fairly short fashion, but I'm going to do it, we have 45 minutes, now what, 35 minutes? Not 4.5 hours, not, so I'll give you the Reader's Digest version. And for people who have taken one of my classes, that's somewhere in between Inter-American Government and Civil Liberties, is Reader's Digest. So what I'm going to do then is look at the Equal Protection Clause very quickly for context, and then we're going to look at Plessy. We're going to then, after looking at Plessy, look at the roots and origins of contemporary 14th Amendment or contemporary equal protection jurisprudence. What does equal protection mean in the modern era? And then from there, we look at Brown. Okay, so that's Plessy, Caroline, Brown. Very, very simple. And then I'm going to shift gears a little bit and look at what's happened since Brown. And there have been 4 significant changes in the development of constitutional law in this area since Brown. Each one has moved away from Brown and arguably, and that's my argument, towards Plessy, back towards Plessy, which again is deeply, deeply disturbing. So let's start first then with the Equal Protection Clause and get a sense of what we're talking about. See, that was really nice. Okay, so equal protection of the laws. And I want to simplify this as much as possible, even though there's nothing simple about the Equal Protection Clause. In fact, if you blink, you'll miss it. Okay. Oh, come on. I think I may need to just stand there. Stop.
I can move the camera.
I mean, I'd like to have the stupid thing work. Here we go. Hang on. The buttons are getting stuck. This thing is obviously a little bit defective. All right, 1, 2, I just need to hit really hard. Nah, change it. It's not gonna, it's gonna keep moving over. I'm gonna have to do the old manual approach. Okay. Yeah, that will work much better. Let me get back to, let's see. And equal protection. Okay, so this is the language of the Equal Protection Clause. And again, people are familiar with the Equal Protection Clause, but to simplify this, we've got basically a nice simple phrase: no states shall deny to any person within its jurisdiction equal protection laws. But what the heck does equal protection laws mean? And the truth is, we don't know, and part of the debate between Chief Justice Roberts and other members of the court, and that the court has struggled with in the development and post-development of Brown, is precisely that language with a couple of other questions. One is, the Equal Protection Clause pretty quickly became a way to analyze group-based discrimination. And there's a reason for that, because if you say equal protection, deny to any person equal protection of the laws, the justification and the background was people were not being given that because of a classification, because of race, because of gender, because of sexual orientation, because of disability, because of various other characteristics. So it pretty quickly, early on in our history, became about groups. Now, that's not inevitable in the language here, but that's what we got. So that's the first thing. Second point, we don't know precisely what equal protection means. Some people will tell you that equal protection means that the law treats everybody exactly the same. Others will say equal protection of the laws means that outcomes need to be the same, which means that you're going to treat some people differently than others. And other people will take a different approach. It's not clear what we mean by equal protection, and that's an ongoing struggle. The third component here is state action. No state shall. And depending on how you read, how carefully and how restrictively you read the restriction here, that can mean that the 14th Amendment can only reach legal discrimination. It can also mean that when Congress legislates, or when the Supreme Court or a federal court acts to restrict what a state is doing, they can look to the literal language of what the state's doing, or they can look at the results of what the state's doing. And it's not always clear to what extent the state is involved. One of the early cases interpreting equal protection in terms of state action, getting a little ahead of myself, but I'm going to mention it now, is a case called Shelley versus Kramer. And what happened in Shelley, and this was almost two decades before Brown, a full decade at least before Brown, there was a restrictive covenant, and people who lived in this one neighborhood were not allowed to sell their house to anyone of, I'm quoting, the Negro or Mongolian race. Don't want those people in our neighborhood. Well, that's a private covenant, right? It's not state action. And so presumably that's enforceable because equal protection can't stop it, because equal protection only pertains to state action. But the Supreme Court, taking a more aggressive role in terms of the ability of the state, or the ability of equal protection to reach something that doesn't look like state action, said, how are you going to enforce that? The only way you enforce that is to go into court. And if you have to go into court, that means the state is behind the restrictive covenant, and therefore that can be limited by the 14th Amendment. And so depending on how you read state action, how you apply it, and again, Brown took a very aggressive approach to state action. Okay, so if we start with the premise that that's what we have with our 14th Amendment, let's take a quick look at Plessy. I'm not going to touch this thing again. It makes me nervous. Okay, so what did Plessy do? Most people are familiar with Plessy, so I can spare the short history lesson, except to say that there was a little bit of a Rosa Parks component to Homer Plessy. This was a test case. And what the court did in Plessy versus Ferguson was to establish separate but equal as an understanding and application of the 14th Amendment. Equal protection of the laws includes separate but equal. Now, Brown obviously repudiated that, but Plessy stands for more than separate but equal, and because that line was so famous and so significant, we sometimes forget what else Plessy stood for. One is the idea that the law is neutral. And again, these are quotes from the Plessy decision. The underlying fallacy of the plaintiff's argument is the assumption that the enforced separation of the two races stamps his words, the colored race, with a badge of inferiority. If this be so, it's not by reason of anything found in the act, but solely because the colored race chooses to put that construction on it. I've heard that referred to as the, oh, those silly Negroes argument. The law is neutral. The law is not neutral, but the law is neutral. It's what they take away from it and choose to believe about it that's not neutral. That's Plessy. What else is Plessy? The restrictive view of state action assumes that social prejudices can be overcome by legislation. Legislation is powerless to eradicate social instincts. If one race be inferior, the Constitution can't put them on the same plane. And the message there, other than the obviously discriminatory language there, is legislation can't fix this stuff, and therefore legislation is not allowed to fix this stuff. You can't use law to get at discrimination. That's not the purpose of law, and law doesn't reach it. It's separate, not separate equal, but the 14th Amendment's Equal Protection Clause is not something that can be used in these instances. Okay, so that's Plessy. Now I want to jump into the 20th century because the 20th century is a little more interesting. Okay. All right, so what do we mean by equal protection in the 20th century compared to the 19th century? Obviously, Plessy is going to get repudiated pretty quickly in Brown, but Brown had to have its roots somewhere other than just Plessy's wrong, let's reverse it. And what happened with Brown, with Brown is the product of a whole bunch of development in the case law. I'm going to focus on the most important and in some ways most bizarre way that law developed and significant constitutional law developed in the 20th century. Okay, we all know that Plessy was the law of the land for close to 60 years, and that was enough to codify and institutionalize racism in the laws of almost every state. And in 1941, Chief Justice Harlan Stone radically changed 14th Amendment doctrine, both equal protection and the due process clause, which I'm not talking about tonight, but incredibly significant as well. And he decided we're not going to be spending our attention, we the court, on economic regulations the way we were before the dramatic change in the Supreme Court in 1937, when it flipped on New Deal policies. Basically, Justice Stone was saying, what else are we going to do? And he knew just the way to explain a significant change in constitutional law. He wrote a footnote. I'm not kidding. For those of you who are not familiar with the Caroline footnote, he takes a case about filled milk, restrictions on adding milk fat in the butter products and stuff, really an insignificant little case, where the Supreme Court reaffirmed its position on economic regulations. Meanwhile, he writes this footnote. And in footnote 4, which is legendary for being a ruminations that become law, he says, this is the kinds of things that we might want to pay attention to. And I'm going to give you a little quote here. Nor need we inquire, I didn't actually post it here, nor need we inquire whether similar considerations enter into the review of statutes directed at particular religious or national or racial minorities, whether prejudice against discrete and insular minorities may be a special condition which tends seriously to curtail the operation of those political processes ordinarily to be relied upon to protect minorities, which may call for a correspondingly more searching judicial inquiry. What he did in this footnote is create a framework for looking more carefully and more exacting scrutiny. The term strict scrutiny comes from this, of restrictions on fundamental rights and discrimination against what he said discrete and insular minorities. And he was very clear about setting up a regime in this footnote. He may not have intended this footnote to become the framework, but it became the framework. And so what we get out of this footnote is, first of all, suspect classes. I said earlier that this point about the 14th Amendment's equal protection language targeting discrimination based on groups. Justice Stone talks about discrete and insular minorities. Minority groups that we can identify in society because they have been subject to discrimination and they don't have the political power to protect themselves adequately because of the status and discrimination they have faced. So that's one reason, one explanation for treating groups differently under equal protection, because that's necessary because of the situation that the political system has put them in. Secondly, he makes it very clear that he's talking about harmful discrimination. Discrimination is merely treating people differently, but you can discriminate to help a group. And Justice Stone sets up a framework where that's not a problem. This is the problem. You treat people, you identify a group and then treat them negatively in the law. Now you got something that maybe the court can address. But they were very clear. They treated benign and invidious discrimination differently. Harmful discrimination is something you can regulate, something the 14th Amendment can reach. Okay, he also created standards for judicial scrutiny, strict scrutiny, and rational basis. I'm going to skip that discussion. That's a whole different level of detail that we don't need to get into. Okay, and the last thing he did not talk about, but I mentioned the Shelley versus Kramer case. The state action doctrine in the 20th century is a limitation on abuse of power by the national government and the courts in particular, but there's some play in the joints. And there's an ability to say, reasonably, the government is involved here. And if reasonably the government is involved here, then the courts can act and potentially Congress can act to regulate what the states are doing. And again, they can do it indirectly. You can have, for example, state policies, and I'll just throw out this example, state policies that lead to inner cities being predominantly one race. What kind of state policies? Banking policies, the way districts are drawn. There are a number of ways where states can be involved indirectly, and you end up with, it's not so simple to say, well, people choose to live in the inner cities versus the suburbs, the state is involved there. Under this theory that was espoused in Shelley versus Kramer, that would be actionable. The state, the court could step in, the states could be required to fix that which they have wrought, even if they didn't do it directly. Okay, so that's the Caroline Products kind of establishment of a new framework. And from that framework, we get Brown versus Board. And what Brown versus Board does is not only build on that framework, but build on a framework that is theoretical, because it was a footnote, it wasn't applying to a particular case. And again, Brown is the shining example, but it's not the first and it's not the last example of applying some of that doctrine. Brown, first and foremost, repudiated the key components of Plessy, obviously separate but equal, but also the concept of neutral laws. Under Plessy, neutral laws satisfied equal protection, right? The law, what did really create the discrimination? The discrimination was in the minds of people. The law on its face was neutral. White people have one car, black people have another car, right? That's not clearly one is inferior. State action allows a rule for the law in fixing racism is another thing that Brown changed from Plessy. All deliberate speed. Okay, but what else did Brown do to, if you will, the Plessy legacy? One is Brown expressly rejected the colorblind constitution concept. And that's pretty clear just reading the discussion. And it's actually fascinating to go through the discussion of why the court is taking this position in Brown versus Board. They looked at the social science data. The court did not have a track record of looking at social science data, but they did in that instance. They looked at the impact, and they said basically that the legal and political edifice of Plessy is not workable. The colorblind constitution is unable to promote equal protection because equal protection means the law is a tool for equality. The law is not just something that treats everybody the same and satisfies equal protection that way and ignores what's going on in society. Brown was, again, as I said, a realignment of the Constitution with equality in ways that it couldn't do before under this theory of a colorblind constitution. And again, if we look at the language, I'm going to skip reading the language here, but the Chief Justice Warren's discussion of the inferiority that is felt in separate but equal education, if you contrast that with the statement that was made in Plessy about, well, they're just imagining a slight with the cars, is with the railroad cars, is really fascinating. So the interplay there, the change, the development of what Brown did to, if you will, the legacy of Plessy is fascinating. It's not just separate but equal, no, we fixed that. Fixed, if you will, a lot more. In short, Brown was a call to arms for the courts to remove discrimination from the legal system, and the legal system to remove it from any policies within its reach. And again, that's a significant change. The Supreme Court did not push the political branches too far or too hard, because one of the little secrets about Brown versus Board, does anyone know how long it took for all the districts to fully and completely comply with Brown?
Over 10 years.
Over 10 years? If you dig a little deeper, it'll be really scary. Kansas City, 1990s, there was a case where Kansas City had still not fully, completely complied with Brown. That's fascinating is a polite word, but I'll just leave it at that. Okay, so the colorblind constitution after Brown was pretty much gone. The idea that the Constitution has nothing to do with race. The Constitution had to act in this context. You can't fix racial discrimination without looking at and addressing race. And again, Brown walked through the suspect classes, the invidious discrimination, and state action still being a limitation, but a reasonable one that allowed some linkage to government and policies. Okay, so with Brown doing all of that, and again, imperfect, still some limitations. Two other notes about Brown. One is the justices in Brown understood that state action was implicit in the entire edifice of white supremacy. Obviously, the case was limited, but there are some writings by Chief Justice Warren. He was fully aware that education was the first thing they could touch. Not necessarily the only thing. And again, the court ended up not going as far as he would have liked. But before, well, you can look at the criminal justice system. And you can look at local and regional economies and the disparities, the racial disparities there. And you can look at voting in elections and the limitations of voting rights that began in the 19th century and extended and basically continue to this day along racial lines. But even before Brown, we were seeing some movement towards challenging the premises here. We saw it in Shelley versus Kramer, we saw it in a few other cases. But post-Brown, there was some pretty dramatic stuff in the first few years. The only case in United States history where every justice signed an opinion was a case called Cooper versus Aaron. And it was written, again, you had the opinion written and all 9 justices signed their names to the majority opinion. It's only happened once, and it happened because Little Rock was defying the court in refusing to desegregate their schools. And they were threatening violence. The state and the governor was threatening violence. And the court said, the fact that you're threatening violence can't be a reason, and we have great sympathy for the school district that doesn't want to endanger anybody. But we told you what to do. We told you you have to fix this problem. And if the fact that people are defying our order, if that's a reason for you not to comply, then we have a big problem. And the court took a very aggressive approach. And that very aggressive approach was driven by, again, I would say, the premises established here in Brown. Okay, now, what I want to do now is look at what happened in the three Chief Justices before Roberts. And I'm not going to go through any extraordinary detail here, but I want to illustrate very quickly the post-Brown erosion of equal protection as established in Brown. And for each of these major developments that I've been talking about that came about through the Caroline footnote and through Brown versus Ford, there has been a corresponding erosion of those developments in the court cases in very deliberate ways. And the most disturbing part of that is they keep referencing Brown as if Brown stands for these changes. So, first of all, suspect classes. And how am I doing on time?
You've got about 20 minutes.
Okay, I'm okay. I was worried about doing the short version of this. I already made it the short version. Okay, so I said before that Brown had established and had built upon an idea of suspect classes. Coming out of the Caroline footnote, what the Supreme Court did was say there are classes of people that need protection, and that's one thing that equal protection stands for. It's not classifications, it's classes, it's specific classes of people. It's not race, it's African Americans, Native Americans, groups that have been discriminated against. And that's how we identify discrete and insular minorities. Well, if you look at that line, and actually, I don't need to mention every single case. I've been trying to scale back some of the cases here. I've chosen a couple of cases to illustrate each chipping away or each erosion. I used the term erosion here, and then I used chipping away earlier. I don't know, you guys like tides or beavers? No?
Beavers.
Beavers? Okay, chipping away. We'll go with chipping away. The classes versus classification, you really have to go to the gender cases. And the Supreme Court in the 1970s started looking at gender discrimination. Actually, it created a whole new classification, not classification, but a whole new level of scrutiny for gender. We had strict scrutiny for, the Supreme Court looking at discrimination based on race, targeting African Americans, targeting Native Americans, and they applied strict scrutiny, which is the highest level, the gold standard, but it's basically, if the government's going to discriminate based on that, they're going to have to jump through the greatest number of hoops. The test that it has been created by the court to allow them to be able to engage in that kind of discrimination is almost impossible. And then the rational basis test, which applies for most groups, and people can argue about whether it should apply for most groups, but physical disability, the Supreme Court has said no special protection. And all the government has to do is meet the rational basis test, which is a pretty low standard. But with gender, the Supreme Court came up with an intermediate standard that's kind of in between the two. And more importantly, the court in the gender cases, many of those first round gender cases in the early to mid 70s were about men claiming discrimination because of their gender. Now, historically, we think of women as the class, the suspect class, but the court was looking at classification because it was looking at men. Men really don't fit as being a suspect class because they have a lot of political power. They have not historically been in a position to be discriminated against because they are the ones that can do something about it. But in those series of cases, and again, without giving a whole lot of detail, Craig versus Boren, Michael M. versus Sonoma County, I could go on. The Michael M. case had to do with statutory rape. And if you engage in sex with a minor female, you go to jail. But if you engage in sex with a minor male, you don't. And Michael M. sued and claimed that that was unconstitutional because it treated men and women differently, which it did. And under the test that the court created, is there a justification? Right? You can discriminate if you have a good enough reason. But again, the most important thing about that line of cases, it developed the mentality in the court that it's not so much the class, it's the classification. So it's gender discrimination, that's the issue. You translate that concept to race, and now it's not African Americans being discriminated against, it's discrimination using race that becomes the test. And if you combine that with part 2, you are talking about a pretty significant change. By the way, for the record, does anyone know why the court upheld the Michael M. decision or ruled in favor of the state? You have to have an important government interest. Teen pregnancy. Last time I checked, men don't get pregnant. And so the discrimination was justified by an important government policy. Is that the right decision? I don't know. That's what the court said. In any event, this plus this starts to look pretty significant, because if you now say that harmful and benign discrimination get treated the same, and then you change suspect classes to suspect classifications, you can see where that starts to look an awful lot like something other than Brown versus Ford. Now, what happened here? How did we get that change from invidious to benign? The cases that, again, developed that, and I said I would use some examples, there's a long line of cases that developed that, but the early affirmative action cases were the drivers of this change. And there was a case called Richmond versus Crossan that somewhere between discussing government contracts and discrimination and groups and non-groups, they slipped in the fact that Brown versus Board stands for discrimination is wrong regardless of whether it's helping or hurting. No, but that's what they said. So it gets slipped in. It wasn't a misquotation of Brown, it was just a reference. Brown versus Board supports this position. But what happened in the Richmond versus Crossan case, and then stated in Shaw versus Reno, which was a gerrymandering case, which basically was an affirmative action gerrymandering case. The Supreme Court was asked to review the creation of minority majority districts in North Carolina. And Justice O'Connor said, absent searching judicial inquiry, there is simply no way of determining what classifications are benign or remedial, and what classifications are in fact motivated by illegitimate notions of racial inferiority. It's too hard. We can't decide if something is designed to help or designed to hurt. So we're going to say that all discrimination is presumptively unconstitutional, on top of saying that classifications, if you use race, that's a problem, instead of if you use race targeting certain groups. And if you use race whether to help or hurt, that's a problem. And these, make no mistake, are being associated with and claiming the legacy of Brown versus Ford. My favorite of the lines that got attributed to Brown was, and I'm quoting this one too, a racial classification, regardless of purported motivation, is presumptively invalid and can be upheld only upon an extraordinary justification. And that's a somewhat obscure case called Personnel Administration of Massachusetts versus Feeney. And it was cited in, shockingly, that Parents versus Seattle case where we got that, glib line from Chief Justice Roberts about the way to stop discrimination based on race. He cited in the opinion that case and associating that statement with Brown versus Ford, that it's about classifications. If you use race to identify and you use it to help or hurt, that's presumptively unconstitutional because that's what Brown says. Okay, now, and again, any classification, any use of race triggers strict scrutiny. It's not neutral, it's not colorblind. That's where we are with those first two. the colorblind constitution starting to creep back in. You can't use race, and it doesn't matter why. The last element here, where we see some erosion, and by the way, the strict scrutiny colorblind constitution is the broad concept here. I'm not going to go into specific cases for this one. The state action doctrine. Brown versus Board and the cases around it made it much more plausible for the state to be invoked, for the state to be not indicted, but for the state to be involved in the creation of discriminatory policies and be connected to discriminatory policies, therefore giving the opportunity for the courts to act, or for Congress to act, or for the requirement for the states to fix what they caused. And what we've seen since Brown is a rolling back of that as well. And we've seen it in a few different ways. The clearest example of the state action doctrine being altered is in the early affirmative action cases dealing with busing and dealing with inner cities. Not the first couple, but maybe the second couple. And there's a case called Milliken versus Bradley. Again, illustration. In Detroit, there was one district that had discriminatory policies based on race. Clearly, you can fix that. Right? It was caused by the state. State policies were discriminatory. But when the districts and the broader Detroit organizations looked at how we're going to fix the school system, they said, we can't just fix that one district. We have to have a holistic approach. And they came up with a busing plan that would take people in and out of the suburbs and would desegregate the schools citywide and regionally as well. And the Supreme Court said, no, you can't do that. One reason you can't do that is because you are reaching beyond where the state messed up, and you can't extend the state action doctrine. So if you have a whole bunch of districts and one of them acted unconstitutionally, that's the limit to where you can fix the problem. But also, in that case, the majority said the overall point here is that people are moving naturally to communities to be with people like themselves, and that's beyond the reach of the state. The dissenting opinions in that case are worth a read because they're fascinating. Justice Douglas says, first of all, this is going to put us right back in Plessy versus Ferguson. Well, you should mention that. Talk about. But he said that if you combine this decision with some of the other decisions that the court has been making about education, the financing cases, the Supreme Court decided that education is not a constitutional right, and I'm just not making a statement about that one way or another, but if it's not a constitutional right and economic status is not a protected class, then it is perfectly okay for wealthier school districts to get the money from the state and the poor districts to not get as much money from the state, so their schools are inferior. Since those schools are inevitably in inner cities and tend to be minority, and I said inevitably, I didn't say only, right? A lot of rural school districts are very poor too, but the inner city schools tend to get very little financing. What they are in effect doing, said Justice Douglas, is perpetuating discriminatory school systems, inferior school systems that end up being racially driven. But then he goes on to talk about this concept of state action. And I do want to quote this at length because I think it's particularly interesting. There is, so far as the school cases go, no constitutional difference between de facto and de jure, discrimination in fact and discrimination by law, segregation. Each school board performs state action for 14th Amendment purposes when it draws the lines that confine it to a given area, when it builds schools for particular sites, when it allocates students. The creation of the school districts in Metro Detroit either maintained existing segregation or caused additional segregation. And then he goes on to talk about restrictive covenants enforced by the state. And restrictive covenants maintained by state action or inaction built black ghettos. It is state action when public funds are dispensed by housing agencies to build, again, policies, housing in one place and not in another. It is ludicrous to make the claim that the state had nothing to do with the underlying societal discrimination. But that was the losing side. And the idea of state action today is if you cannot point to the state deliberately discriminating, then the state can't fix it. The courts can't address it. Congress can't step in and pass laws legislating it, because Congress has the power to legislate under the 14th Amendment, but only if there's state action that it's addressing. So we see a pretty significant rollback in all of these areas of the legacy of Brown. And then again, what's most disturbing, and I didn't point these all out specifically, each of these instances, these three, 1, 2, 3 here, in each of these instances, the court decisions point to Brown and say, we're doing that. We're complying with Brown. Brown stands for this. Brown stands for this. Brown stands for this. It really doesn't. Maybe equal protection should be interpreted that way. That's an open question, but this is not Brown versus Ward. Brown versus Ward did not talk about how it's unfair and unjust to the poor white kids that weren't able to go to school with the black kids. It's unfortunate, It talked about the discrimination based on race, based on a particular racial group that was being denied access to quality education. Harmful discrimination targeting African Americans. That was the point, and that's what equal protection was doing. And here, the idea of state action being so incredibly limited has restricted the ability to do that which was being done in Brown versus Ward. Desegregate the schools with all deliberate speed. What that would mean today is only the school districts where you can point to express discrimination. Now, there was an element of that in Brown, but the implication was broader than that, and the language in Brown suggested a more sweeping approach. In any event, so where are we now? With all of this having changed, where are we? Allow me a brief rant here. Private sector discrimination is not exactly on the decline in this country. I won't defend that statement, but it's not exactly in decline. With this reality, removing consideration of race from the governance arsenal to combat racial discrimination is, I really wrote that, counterproductive. Bordering on nonsensical, it sounds more like it. Justices White and Douglas on the rollback of affirmative action cases noted that that's a naive belief, that the discrimination that can't be touched under the state action concept had nothing to do with the state. It doesn't make sense. I mean, they're conscious policy choices that have been made by government to develop a lot of that. And use of race as a political bludgeon is not a way to fix the problem. I'm not going to explain what I meant by political bludgeon except to say that, no, I'm not even going to do it. I wrote it, but I'm not going to do it. The broader themes here are bad enough, but it's possible for these changes to have occurred because large groups in the public believe in this myth of a colorblind constitution. The Constitution ought to have nothing to do with race. Its role with respect to race ought to be that the laws are completely neutral, and what society does and what the non-legal part of the world does can't be touched by law. I'm not saying that the law should step in and fix everything. But the idea that if you have entrenched discrimination and you tell the legal system, or not even the legal system, what you tell the government is you can try to fix these problems, but you can't use race. How do you do that? Chief Justice Roberts says the way you do it is this way. You simply have the law get out of talking about race, get out of legislating about race, get out of enforcing provisions in the 14th Amendment about race. The 14th Amendment means that the race has, even using race, even using it in any way, shape, or form is presumptively unconstitutional. Because again, the purpose of the 14th Amendment is to have a colorblind constitution. That's Chief Justice Roberts. Now, there was a nice response to him. Justice Sotomayor responded in a case a couple of years later. The way you stop discrimination based on race is to talk about it, to address it, and to look at the fact that we have a legacy of discrimination and, got to fix it. A better response to him was a few decades earlier. In order to get beyond racism, we must first take account of race. There is no other way. How do you fix racism without taking account of race? Justice Blackmun has the right idea. You can't. Now, that doesn't mean that, you create a system where there's unlimited government power to do whatever it wants to address racism. But the theory in Brown was that what government was supposed to do was take account of race and fix the problems that government had caused, directly or indirectly, and to do so under a regime that acknowledged that the Constitution was on their side, that the Constitution was about the justice, and the idea of equal protection is equal protection of the laws means eradicating the discrimination that has prevented that equality. Okay, so what does that leave us with? We return to the colorblind Constitution with Plessy instead of Brown as the prevailing interpretation. Then there's something wrong. Now, is Roberts right, or is one of these ones? Makes sense. My personal favorite is that one. I think, again, that phrase about the Constitution being colorblind is stirring. It misses the point, but he really wants to say our Constitution ought to be colorblind. Neither knows nor tolerates classes among citizens. He's saying the Constitution will not tolerate discrimination. Now, I would read that as it's not colorblind. But the point, the Constitution does not tolerate this, cannot tolerate this. And yet, the Chief Justice, I'm going to wrap up with this. The Chief Justice has skillfully codified all of those chipping away approaches into a 21st century Plessy doctrine. Suspect classes have given way to suspect classifications, and I think I've got those over here. Suspect classes are giving way to a notion of classification, that the problem is not targeting particular classes, the problem is using race. You can't use race. And again, you can't use race whether it's harmful or not harmful. In either instance, it triggers the highest level of scrutiny. The court is expected to strike down any use of race for whatever reason. And again, well, I'll just leave it there. Okay. And then the last, again, major point by Chief Justice Roberts is this very limited notion of state action. It's attributable to, if something can be attributable or attributed to de facto, as in discrimination in fact rather than discrimination expressly in the law, then it's untouchable. Even if you could say that the government has a role here, if the argument is, or the argument is presented that, well, this happened in society, it's not because of the laws, okay, we can't touch it, we can't address it. And here's my closing with respect to that. That is what Chief Justice Roberts has been doing. His political task has been to envision a post-Brown, truly colorblind society, and then recast Brown as upholding that vision. You can't overtly disenfranchise minority voters or gerrymander away their voting power. Find another way to do it: photo ID, voter purges, rollback of early voting, and then rail against use of race as a curative remedy. Okay, I said I wouldn't go there. I studied voter suppression for a number of years, and I said I wouldn't go there, and I just went there, so oops. But in other words, what his task has been is to recast the goal of equal protection and the premise of Brown versus Board of Education as the colorblind Constitution of Harlan. It's the quote I had. Never mind that Harlan was actually speaking derisively of Plessy. But hey, that's a good idea. Colorblind Constitution.
That Roberts has limited the reach of the Equal Protection Clause is a travesty. That he's done so in the name of Brown versus Ford and the colorblind Constitution is indefensible. We need to understand what has been done and the gross misapplication of constitutional law that treating that as Brown, that has to be undone. Maybe it means overturning Brown versus Ford if Chief Justice Roberts is correct. But to claim that it's Brown is a problem because none of this is Brown versus Board of Education. None of this is the legacy of Brown. None of this is the understanding, the interpretation. None of the justices who ruled in Brown versus Ford would agree with any of this. And yet it's being claimed as that's what Brown did. That's what Brown does. That's what Brown stands for. None of this is Brown. And yet it kind of is because Chief Justice and a majority of the Supreme Court say it is. Because today, Brown equals Plessy. And somewhere, Homer Plessy is not amused. Okay, thanks. I will take whatever questions people have. Okay.
Yeah, I was actually thinking of a question the whole time, and you kind of just addressed it there, but I do want to get your thoughts on it. It sounds like you're almost making an originalist argument that the way that Brown v. Board of Education, I don't know, I know that I wouldn't categorize you there, right? But it sounds like you're doing that, and I just wondered your thoughts on that.
Well, I mean, I could see a little bit of that. Part of the problem is that it's maybe less originalist and more, if you're going to change a significant precedent, maybe you should be upfront about it. Nobody, I mean, in fairness, nobody's going to come up and say, you know, Brown versus Ford. It was in the 1960s. That was in vogue in political science. Brown versus Ford was wrongly decided, and you know, a lot of books are written about it, talking about the excessive power of the courts. Today, nobody's going to, and even then, you know, we're not saying that the decision's wrong. We're saying that the way it was done was wrong. The problem is that Brown did change some of the interpretation of the 14th Amendment. The danger, and I think the problem maybe gets at your question a little bit, is that Brown is like, you don't say anything about it. Brown is like the great decision, right? But what has happened is Brown now stands for some of the very stuff that Brown reversed. And I think part of my complaint is if you disagree with Brown, disagree with Brown. Don't pretend it means something else. I mean, I was amazed. Some of the quotes I read, there are references. They're not citations. I get it right, you know, but they cite generally Brown versus Ford for this premise. But the fact that the Brown opposed use of race as a category. Brown opposed classifying people based on race. You read Brown versus Ford, and Brown was not talking about racial classifications. It's so terrible that, you know, it's unfair to the whites, it's unfair to the blacks, it's unfair to everybody to use race in this way. That's not what Brown was talking about. Brown was very clearly, look, there's discrimination against African Americans here. Now, maybe this ought to be the correct interpretation, but it's not what Brown did. And so if you're going to change Brown, and again, it's hard to say that's an originalist approach because the very nature Brown is already not an originalist decision. But it is kind of an originalist argument with respect to Brown that I am making. If you're going to change Brown, be upfront and honest about it. And I think politically you can't do that. You can't criticize, I mean, you can criticize Brown, but you can't say Brown versus Ford ought to be overturned because it talks about suspect classes instead of classifications. It talks about discrimination against people, harmful discrimination against African Americans instead of discrimination based on race. And therefore, we should overturn Brown. You're not going to get that. So what they do is they just say, well, Brown stands for this. Brown stands for neutrality towards race. It does not stand for neutrality towards race. There's no way you get that from Brown versus Board of Education. And to be honest, the state action part is the only part where Brown might be deemed consistent, because Brown did clearly address school districts where there were laws that discriminated based on race. That was the case. That was Brown versus Board was the case. There are school districts that are discriminating based on race. We've ruled that's unconstitutional, now fix it. Some of the cases before Brown, some of the cases after Brown took cast a much wider net, and that's been reined in. Now, in terms of my thesis here, would be less concerned about this if it wasn't part and parcel of the rest of it. I can see the state action stuff making a little bit of sense, but again, and I don't know how many people were at Dr. Gracie's talk. The claim that the development of inner cities as like where minorities live, the claim that government had nothing to do with that doesn't work. And yet that's the basis for saying that you can't use race to fix those problems. And when I say you can't use race, if the government's going to create educational policies or economic policies that benefit people based on race because of a long-standing discrimination there, you better believe Chief Justice Roberts and the Supreme Court majority is going to strike that down because they're using race. And they're going to say that that's Brown. That's the other part. I slipped up on it. They're going to say that Brown versus Board says we can't do that. I don't know if that answered the question.
There are several questions on Facebook. So first, to clarify, are you saying the Constitution should be colorblind and therefore not interfere in issues of society versus law? And if so, how would the nation's society go about making change?
I'm actually saying almost the exact opposite. That the Chief Justice Roberts is saying that the Constitution is colorblind. He doesn't ever use that phrase, but his position is that equal protection means the law is neutral towards race, and if you take account of race, it's presumptively unconstitutional. That's the doctrine right now, is if you use race to help or to harm, to target a group that is in the majority, to target whites, to target blacks, doesn't make any difference, it's presumptively unconstitutional. I think that's wrong. And I think that essentially is the Plessy version of the colorblind Constitution. So I'm kind of saying the opposite. I mean, the colorblind Constitution was originally used to criticize the Plessy decision. And my point there was, just a little terminology issue. I think that he used the term the wrong way. Our Constitution is colorblind, it knows no caste system. I think the response should have been the Constitution isn't colorblind because it refuses to recognize a caste system or allow a caste system. I mean, there shouldn't be any kind of a caste system in this country, clearly. But I don't know how we, as far as the question almost asks, how do we fix the discrimination? I mean, in a sense, and the best I can do is not this way. We have to take, and I think if I can jump backwards here, I think we got to start here. Justice Blackmun, if we want to, use concepts, I think the only way we get beyond racism is to take account of race. I don't think there's any other way to do it. We have to. One of the things we're seeing more and more of right now is we're seeing a lot of discussion about race. I don't think we can do it without doing that, but in the law, I think the law has to address race to fix the entrenched racism in the legal components of the system. I don't think you can say, well, the law is colorblind, the Constitution is colorblind, and we, the courts and the law, can take no account of race. the way to stop discrimination based on race is to stop, when he says stop discriminating based on race, he's talking about the court. The court should treat all racial classifications as unconstitutional and not allow any of it, and get completely out of the business of doing anything about race. I don't think that fixes the problem. I think that allows the problem to get worse. But again,
Well, that
reasonable
actually-
people can disagree.
Yeah, that actually triggers yet another question, because apparently the questions are flowing. So if any use of race, either to help or to hurt, is unconstitutional, what would that mean regarding affirmative action? Is that entire policy unconstitutional?
According to the current Supreme Court, yes. The current Supreme Court has upheld exactly one affirmative action decision in the last 2 decades. Might be 2, actually. The Texas, no, it's 2. The Fisher versus Texas, or Texas versus Fisher, and the Grutter versus Wallingford. But they've struck down almost every affirmative action policy based on the premise that it's using race. It's presumptively unconstitutional, and they couldn't meet strict scrutiny. The only ones they've upheld were the Michigan Law School, where Michigan, I mean, what the law schools do is they budget. They say we're holistically looking at every candidate, and we look at race, but we look at everything else too. And we don't pick anybody based on one category. That was upheld because while they did use race, they used it along with everything else, and it was viewed as meeting strict scrutiny because race was not the driver. You can use every category under the sun. If race is one of them, that's okay. They upheld it. 5-4, by the way. And then the Fisher versus Texas case just recently, where the state of Texas has that policy where if you're in the top 10% of your school, you get in the University of Texas. And this person didn't make that top 10, and then they were denied through the other criteria. They said, well, black people got in and I didn't. And as I understand the second version of that case, it went to the Supreme Court twice. There was enough evidence that, yeah, some black people got in and you didn't, but some white people got in that you didn't, and some black people didn't get in who were ranked higher than you. And there's no way that you can document that you were harmed sufficiently. But that's it. I mean, every other affirmative action decision, the Supreme Court that has come to the Supreme Court, they have struck down the affirmative action policy. So yeah, that's when they say is that unconstitutional. Yes, it is. According to the majority right now, yes, it is.
Okay. Last question so far, and this one's from Casey. Since people make similar arguments against the passage of an Equal Rights Amendment, do you think the recent push to pass has any chance? And if so, could it stand up to the precedent you discussed this evening?
An Equal Rights Amendment being the gender. I think it can, and the reason I think it can is because of the difference in classification. And this is one of the, on the one hand, most perverse parts of what I'm talking about, and another way, one of the most logical parts of it. It's kind of weird, but let me see if I can explain that. Race gets strict scrutiny. Race and national origin gets strict scrutiny, and pretty much nothing else does today. There was a time when a couple of other categories, but basically you're looking at race, the highest standard. Gender only gets intermediate scrutiny. Now, first of all, if it's a constitutional amendment, it doesn't matter. The court can't strike down a constitutional amendment. But if a law was passed that established gender equality, and it was challenged as violating the Constitution, they'd look at it under intermediate scrutiny, which is a lesser standard. Is there an important state interest, and is the regulation no greater than necessary? And under that standard, I think strict scrutiny would fail, but under that standard, I think it probably could be upheld. Again, if it's a constitutional amendment, all bets are off. A constitutional amendment can't be found unconstitutional. So if it passes as a constitutional amendment, then there's no issue. It becomes part of the Constitution. The comment about things being partly perverse and partly kind of workable is if you identify race as a suspect class, as the highest, the highest tier in any discrimination, be it harmful or helpful, that means that if you're looking at racial discrimination and you're trying to fix racial discrimination problems, you can't use race because it's presumptively unconstitutional. That means that it's very easy to pass, it's very difficult to pass laws that help somebody based on race. But it's also very difficult to pass laws that hurt somebody based on this. And so in a very weird sense, it might end up protecting people based on race. On the other end of the spectrum, where the Supreme Court in its infinite wisdom has said that sexual orientation is not a protected class at all, and physical and mental disability are not protected classes at all. And I get asked that question more than any other questions in my classes. Why is that the case? And my answer is, court. That's the court. I don't get a vote. But that means that it's very easy to uphold a law that discriminates based on sexual orientation, but it's also very easy in terms of the ability to have that upheld. The Supreme Court is almost certainly would uphold discriminatory laws based on sexual orientation under the rational basis approach. However, it's also likely to uphold laws that protect groups under rational basis. So if you can get laws passed that help, they're going to be upheld. Now, if you're a minority group and you think you lack political clout, that's not good news, because then those laws get passed and they don't do very well for you. The saving grace there with the court is that the court has started to look at those classifications with a little bit more teeth. So let's say rational basis, but we're going to look at it a little more closely. And they actually struck down some laws based on sexual orientation because the court concluded that the only reason those laws were passed was we don't like them. And that's not an adequate justification. And they did that in a few cases. But yeah, when you're looking at a different standard, as soon as you get beyond race, it gets easier to uphold some of those policies. If you're going to discriminate based on gender to help or to hurt, you have to meet intermediate scrutiny, and intermediate scrutiny is not as hard. Whereas race, it is terribly difficult. As soon as you use race, presumptively unconstitutional. If you're using gender, presumptively 50-50. And if you're using other categories, presumptively less. So again, it's easier to uphold those laws.
We've got some former students who are saying hello. I'll let you read their comments when we're done.
That'd be nice. Yeah, former students are awesome. By the way, just heard from a couple of former students that got big law school scholarships. So you got that. Very excited. Yeah.
So the recent case where instead of writing for the majority, did they apply gender identity to the second tier scrutiny? Is that?
Gender identity is down. Well,
Is that what they just did with Gorsuch, right?
Yeah, there's actually a little bit of I want to say confusion, but there are a couple of cases that the Supreme Court just decided that suggested, and I have to say suggested, that gender identity is being lumped in with gender.
Right.
I mean, I think that makes sense. I think that makes more sense than the alternative. But they looked at a case involving a couple of trans people and a policy of denying them insurance with a company or removing them, in one case firing them. And the court said they were protected by the statute that forbade discrimination based on gender. So that seems to be the direction. I mean, it was not a constitutional case, so it's hard to say where they're classifying it. But I mean, gender identity, again, we could just stand up here and say gender identity ought to be treated the same as gender. It ought to be the same thing. But is that what the court will do in a case where someone's challenging a discriminatory policy that refuses to look at gender identity? I mean, I don't want to predict that. I know what I'd like to see them do, but I don't know if they would do that. But that was just last year. I think those two cases, but they weren't constitutional cases, so you can only take so much away. They interpreted the statute that way, and that's a very hopeful sign because the statute on its face didn't talk about identity. And it may very well have been a stretch given what the statute said, and if that's the stretch, that at least suggests where the court might go with this.
Thank you, sir.
Well, thanks for coming, everyone. Figure out why my things stopped working. That was amazing, right? I should get it back to the beginning, right? See no, now it's working.
Of course.
I think the button got stuck because it was like I would push it and nothing would happen, and then I think it got stuck and just ran through the whole